substantive suit together, enabling this court to deliver a more informed, comprehensive, and just decision that accounts for all relevant circumstances and factors in this important matter. Such a unified approach will further provide context and clarity, and also afford a clearer understanding of the issues raised in this interlocutory matter and their impact on the main suit. Having therefore diligently analyzed all the material processes on the record in this instant application and listened to oral submissions by learned counsel for the parties, our decision is to reserve our verdict on the interlocutory application until the final determination of the substantive suit, at which point we will render a comprehensive judgment that addresses all aspects of the case, including the current application for injunction. In conclusion, the decision of this court on this application for an interlocutory injunction is hereby deferred to abide the outcome of the determination of the substantive suit.
My Lord, we are grateful. Lady, I believe that is fair and equitable.
Ones that the court thinks can be better dealt with in a substantive action. And it's permissible for a court to do that. There's nothing unusual at all. The court actually referred to an existing rule on injunctions. And so I think that the court is fair in coming by that approach. I mean, if at this stage the process have not been transmitted, and there must be a reason for that. The reason is that there was this application for interlocutory injunction pending, and the court has still not disposed of the application for interlocutory injunction. The court said the determination of that application for interlocutory injunction should abide the determination of the main case, and for that matter, it is reserving its determination until the main action is heard. It tells you that the application for interlocutory injunction is still pending.
Those are some visuals from yesterday after the court proceedings at the Apex Court. Joining me in the studio to dilate on these matters, Richard Kweku is head of our legal desk. We still have Kweku Paintsil here, a lawyer. I'll start with you, Richard. Just walk us through what happened yesterday and what the significance is of what happened.
So currently there are two schools of thoughts, and Richard Delaskai and Dr. Amanda Odoi, they've told one line. They feel that the manner in which this entire bill was brought to Parliament was fraught with a lot of challenges. Indeed, there are constitutional breaches. They cite Article 108 that states that whenever a bill is being sponsored and it has an implication on the
consolidated fund.
Exactly. So it should come from the presidency and not from a private member. So it so happened that this bill was a private member-sponsored bill, and it has far-reaching implications on our consolidated fund. And so that is why they say that the financial impact analysis was not done before this bill was actually entertained in Parliament. And so it shouldn't have even started at all. Parliament had no business entertaining this bill at all. In fact, if you go to legal jurisprudence, you realize that this private members bill, the first one that was fashioned out was in 2019, just as the Attorney General said. Yeah. And so it didn't really create this kind of reaction because it did not have any impact on our consolidated fund. But this one has obviously far-reaching implications on the consolidated fund, and that is why they went to court seeking an injunction restraining the Speaker of Parliament, its agent assigns, and all of that from transmitting the bill that has already been passed to the presidency for his assent or otherwise.
But that is also topical, controversial, because it's been 4 years plus since private members' bills have been accepted, and other bills have seen the light of day. The question now is, why not this one?
Okay, so why not this one was the question I answered earlier, that it has financial implications.
Right.
So
that is what is being raised now.
Exactly. And so once there was something like that, then it means that it ought not to have been entertained. If a bill comes to Parliament and it will have a border on our funds, then it should rather come from the presidency and not from a private member. And so that is why this case has become very topical, and we are all talking about it. But the other school of thought also indicates that, well, Parliament's work is not done until the bill that has been debated upon has been passed, is transmitted to the presidency. So why arrest the bill that is currently set in motion on its way to the presidency? And so that is what really is in contention now. Yesterday, we were expecting that the Supreme Court will either grant the application filed by the two or will refuse the application filed by the two. But it so happened that they said, well, their verdict is ready, but because some of the pleadings that are currently in the interlocutory application also find place in the substantive suit, it will serve the ends of justice should they do some kind of consolidate the two and then give one verdict so that all parties would be happy with the ruling that will come. And so that was really what happened. So they have reserved their ruling, and then they've asked the parties involved to file the necessary processes, and they are pushing for an early trial. And the early trial, when we asked, is that it is also dependent on the processes, how the parties will come together during their meetings and all of that.
Exactly
to do that. And they were also pushing for an expedited one. But you know that legal vacation is also
just around the corner.
Exactly. So by the time, and so people were asking, so what happens if this substantive suit is not heard, and then the life of this parliament expires? What happens to the bill? So that is where we are.
That leaves the bill in some sort of limbo, technically. But let me come to Kweku Paintsil and find out. What do you make of all of these developments? We've had conversations in the past on this LGBTQIA plus bill, and now we find ourselves in these turbulent legal waters. What is your reading of the situation?
It's more about politics than even law.
It's more about politics than law.
More about politics than law. And I'll explain it to you. Because we have a funny situation where the majority in parliament are in the same political party with the president. And this bill received an overwhelming vote in parliament. And therefore, the issue arises as to what is the differences in thinking between the president and his own party members in parliament. How come that your own party members have voted overwhelmingly to bring a bill to the presidency, and now we are receiving education from the president's lawyer or the attorney general as to all of this? It's funny. It's really funny. And so this got more to do with politics than the law. And interestingly, none of the people in parliament, I'm talking about the parliamentarians who voted overwhelmingly for this bill, is taking a point on this matter. So it's politics. This is not law. I'm telling you, of course, the Supreme Court will rule. They have a duty to rule on every matter that goes to them. But I'm telling you, it's funny. The question Ghanaians must ask, I'm asking, everybody must have an answer to, what happened? Is it the case that the office of the president is so, separated from the office of the party members in parliament, so that there was no prior discussions and whatever? Because with due respect, I mean, these things, they are not just done on their own. In other words, parliamentarians, they got up and say we're going to propose a law when they have not had a discussion with their own president. Of course, I know the difference between the executive and legislature, but I'm talking about politics. And so what's playing out before Ghanaians, in my honest view, I don't even believe it's a legal issue at all. It's a political issue. And
once the politics is resolved, maybe there will be no need to see all the back and forth. All the
legal drama.
So how then do we resolve it? I mean, yes, you say that it's political. How do we resolve the politics?
Well, I mean, I have come to the conclusion that we've got a bill that's running in parliament which the presidency is not happy with. The presidency or the president of this country is not happy with. I mean, with due respect, if you know the political views and everything about the president, you will appreciate why he personally, as a person, will be opposed to any law of this nature. And because some of these things is law, and we can't separate it with personal views and stuff like that. I've never known the president to have advocated a view against all this LGBTQ. And it will always find expression in the way these things are played out publicly in the courtrooms and whatever. But of course, that's not to say that there are no legal implications for this matter. If the president believes that as a matter of law, this thing ought to come. Because the point is, with due respect, let me put it this way. He says a private member's bill. You think the president himself believed in it, he could have initiated it on his own? Why a private member? Why leave a private member? Why do you why do you set a trap, if I may put it that way? If the president believed in it, then the law would have started from his office. But the point of the matter is that how come that the people in the same party with the president overwhelmingly voted for that same bill with their own president? How this stands is the president from his own party members in parliament. And that's the funny thing that's playing out before Ghanaians, that, oh, okay, we now have a parliament, because it's election year. And
so now the interesting thing is there is a disconnect between the executive
that is so.
And the legislature, even his own members of the legislature. And now the judiciary has been called in to resolve the tussle between two of the other elements. And you see, the point then is, before you come in, Kweku, the point then is, if it is political,
yes,
why is it even in court? Is the Supreme Court going to deal with it legally or politically?
I'll tell you, this is an election year. And the sentiments of Ghanaians is overwhelmingly in favor. I mean, that's the way I feel. I may be wrong. But I get the feeling that our cultural values mixed with the political sense or whatever makes an election year a very volatile year for any decision on this matter. But the parliamentarians know too much that if they place any sentiment contrary,
they'll be punished.
They'll be punished by the electorates. So no parliamentarian, even in parliament, only 2 or 3 MPs, and they were even being embarrassed. I'm sorry, because people are free to disagree. They were being called names. And I recall reading in the newspapers that on the day that it was put to vote, the whole parliament was silent. In other words, there was no one person who voiced any opposition or dissent, which is funny. And they did it for political reasons, for the electorate to know, knowing the sentiment of Ghanaians. But the president, with due respect, has ended his term of office. And he loses nothing. He has nothing to lose whatsoever. So he can play. So whether the executive and the legislature, I'm talking about the executive, the presidency and his members in parliament, agree to play that kind of thing, I cannot say to it. But that's the inference that I can make from what transpired. Because they're embarrassing all of us as Ghanaians. How can, for once, the president and his own members, how can there be such a great disconnect between the president and his own? That's about the only time that there's been such a disconnect between the presidency and his own members in parliament. I'm not too sure that there has been any other legislation in this country where that disconnect has shown. That's
maybe not legislation, but on the finance minister, you remember, but not legislation.
That is so.
Not legislation. Final words. I'll come to you, Kojo. I see you have a lot to.
No, I just wanted to put a question, ask a question. So there are 2 things.
Yes.
So Article 108.
Yes.
That now the applicant says that it infringes the entire Article 108, where
108A, right?
Should they allow, then it will open the floodgates for other people to also sponsor bills, private members, sponsor bills to Parliament that will have financial implication on the consolidated fund. And 2, the other people are also saying that Parliament's work is not done. So what stops the president from receiving the bill? If the president will not even assent to the bill, why won't you receive it? And then the necessary actions will be exerted.
Yes. I see, that makes it the funnier. Because like you put it, in the second of your 2 questions, I've never seen a situation where the president has placed a stop. In any case, this bill was sent to him, from what I know, on the cover of a letter and all of that. But the point of the matter is because
rejected
that
3
is
times.
So. Because, you see, the constitutional provision will move in. I don't remember the exact say, but when the president receives a bill which he does not want assent to, then it gives automatic right to Parliament to vote. I mean, that's what we call a veto. In other words, when the president refuses to assent to a bill when it's presented to him, then the voting to, to send out, or rather to veto the president bill, comes automatically in. So it was a tactical thing that the president is seeking to do when he has received the bill and he claims he has not received it, or for now he's creating a new procedure for the receipt of bills from Parliament. It cannot be, but it's a game, and I will put it that way. So that is to give the president that room. And as long as Parliament also believes that what it did not amount to sending the bill to the president, then there is this kind of, space that's been created. So that's the first part. But I'm saying that is also politics.
Okay.
That is politics. Then your first question relates to the constitutional provision. You know, the first question that comes to my mind is who assessed the cost, the economic cost or whatever of this bill? Who did the assessment and who decided or determined that it would necessarily have to be on the consolidated account? But even the interpretation of that clause, unless the Supreme Court comes out, I mean, I have personally expressed a view on this matter in earlier forums that because at the time that the bill was presented, I remember that it was presided over not by the Speaker, not by the Speaker, but some other person. And there's enough room. Unfortunately, I cannot quote the constitutional provision. It does not even appear to me that the interpretation that is being given to this clause that you mentioned is really right. But because this matter is before the Supreme Court, I will hesitate in pushing that line of thinking. But I've expressed that view earlier on. But even if it is so, the real question is, how come that at this point, the economic cost of this bill, which nobody knows, is being made an issue? I mean, that is the way I will respond to it.
They say that people will be jailed, be sent to prison, they would have to be fed, and all of that.
It's a joke.
Thank you, gentlemen, for sharing your thoughts on this all-important matter. Only time will tell what happens to this LGBTQIA+ bill. With time, we'll get to see. But those who joined us for this conversation, Richard Kweku Paintsil, he is head of our legal desk, and we also had Kweku Paintsil, a lawyer.